I would say good news and bad news with regard to 2022. The good news is after 2 years of COVID, things largely returned to normal in Sacramento. I would say the bad news is after 2 years of COVID, things largely returned to normal in California.
Good morning, HR. I'm Mike Coffey, and this is the podcast where I talk to business leaders about bringing people together to create value for shareholders, customers, and the community. Please follow, rate, and review Good Morning HR wherever you get your podcast. You can also find us on Facebook, Instagram, YouTube, or at goodmorninghr.com. Despite what is often referred to as a mass migration of businesses leaving the state for Texas or Florida, California still leads the country in the number of employed persons within the state. Regarded by most observers as one of the most, if not the most, employee-friendly states, employment laws and regulations in California are so unique that HRCI has a California-specific certification for HR professionals. Given its size and progressive labor laws, what happens in California might be seen as a bellwether of where federal and state employment law may be trending over the next decade. Joining me to discuss California employment law is Michael Kalt. Michael is a partner at the San Diego law firm Wilson Turner Kosmo, where he helps employers and HR professionals stay compliant in an always changing California legal landscape. He is also the government affairs director for CalSHRM, the state SHRM council. Welcome to Good Morning HR, Michael.
Thanks for having me, Mike. Pleasure to be here.
So, as I said, there's a whole HRCI certification just for California law. But generally, how would you describe California's labor law landscape to an outsider?
I would say the analogy I use is we are on the front lines. And I say that in a couple respects. First, you said what happens in California may be a bellwether. I 100% agree with this. I use the old cliche, what happens in Vegas stays in Vegas, but what happens in Sacramento quickly spreads across the United States. And I would say we kind of have a perfect storm here in California, right? We have, if I use the numbers 61 to 18 or 61 to 19 and 31 to 9, those aren't college football scores. That's the makeup of our assembly. So we have super majorities in favor of the employee groups in both chambers, veto-proof majorities, and we have a governor from the same party. And so right off the bat, almost anything that gets passed by the legislature can get enacted into law. Plus, unlike Texas, where you might have preemption provisions, we don't. And so whatever California does, well, then LA does, San Francisco does, Bakersfield does. And so you're dealing with 13 different paid sick leave laws, 25 different minimum wage ordinances. So it's a challenge.
Limitations on what employers can do about criminal history in San Francisco versus Los Angeles, and at the state level, it's all over the place. Yeah, we deal with that in our relationships with our California-based clients. So you talked about some of those kind of differences. What are for a practitioner, HR practitioner in Texas or Montana or wherever, what are some of the major differences in California employment law that would really indicate we're not in Kansas anymore?
Yeah, I often joke that if you want to know what you can do in California or can't do in California, just think about what you can or can't do in your state, and it's the opposite. But more specifically, I would say a couple things. One, our equivalent of the Family Medical Leave Act, whereas that's 50 or more employees, now applies to 5 or more employees. And whereas in a lot of other states, what you might consider to be best practices, whether it's paid sick leave, bereavement leave, things of that nature, those are all mandated in California. So anything that might be a good idea elsewhere is probably a law in California.
So here in Texas, our legislature meets every other year for 140 days. Sometimes we have a special session to, hash out something. And their main job is to pass a budget and kill a bunch of bills. What's the legislative cycle and process look like in California?
Well, what you just described in Texas probably explains why so many Californians are moving to Texas. We're the complete opposite of that. We have a 2-year legislative cycle. And they're full time. So it begins about January. So we just began the first year of a 2-year cycle, and it runs all the way through September or October. And it's not limited to budget. It is limited to whatever is the limits of someone's imagination. And perhaps because it's a 2-year full-time cycle, the legislators who are elected feel a need that they have to pass laws to justify why they're there in the beginning. So on any given session, we may have 4,000 bills introduced. And what perhaps distinguishes us from some other states, whereas you may have 4,000, but very few make it through the process, of those 4,000, probably 3,000 are making it to the governor's desk. And of those, anywhere between 85 to 90% can get signed into law, because Governor Newsom only vetoes somewhere between 12 to 14%, depending on what's in the package.
And so I'm assuming your legislative body is bicameral. You've got a House of Representatives and a Senate or something like that. And so you've got all those folks for that entire 2-year session. So they are all reelected at the same time. Is that how that works in California?
Very close. We have an assembly and a Senate, and the assembly has 2-year terms and the senators have 4-year terms. So every 2 years, the entire assembly gets revoted in, and then every 4 years, you'll be having an election for Senate, election for governor, and then those assembly members being up for election again.
What are these full-time jobs for these legislators, being a senator or an assembly member?
I would say yes and no. I would say most of them view it as such, but I don't think the pay for a lot of the positions is high enough to be able to let you live comfortably in California. So it wouldn't surprise me if some people have some paid time, paid work, but as a general rule, yes, they view it as a full-time job, January to September, October.
Interesting. Coming from a state with what we often refer to as a citizen legislature, where almost everybody has a real job and they just, tell us what to do for a few months every 2 years. So we're recording this in January, and this episode will be released in February. So what happened in 2022 that might be indicative of the kind of world you live in and the kind of things that are gonna affect employers come, I guess now? Most of that stuff, I guess, kicks into the beginning of January. Is that typical?
Usually kicks into January the following year. I would say good news and bad news with regard to 2022. The good news is after 2 years of COVID, things largely returned to normal in Sacramento. I would say the bad news is after 2 years of COVID, things largely returned to normal in California. And by that, we're back in regular session, full size of legislative packages, no limits in terms of what could be introduced. The only silver lining, such as it is, we only had about 25 or 30 bills this last year. I say only because I think we're still number one in the nation in terms of most employment laws, but that was sort of a down year. And then we also had fewer laws of an earthquake type nature. We didn't have a paid sick leave. We didn't have a dramatic expansion of our paid family leave equivalent. Family medical leave equivalent. But we did have a number of changes. And some of the more significant changes, and in some aspects, we were catching up with the rest of the nation on some things, and then some things we were modifying things we'd recently passed. So, for instance, we introduced a law mandating bereavement leave this year. I think a couple other states were ahead of us on that. And one thing you'll find out about Californians is, to echo Ricky Bobby, if we're not first, we're last. So anytime someone gets ahead of us, we're going to catch up, and then we're going to try to pass you. So we had bereavement leave. We also provided protections for marijuana usage, limiting an employer's ability to discipline employees for recreational marijuana usage. We also expanded our Family Leave Act requirement and paid sick leave to allow time off for a designated person, not simply family members, but now designated persons, meaning pretty much anybody somebody wants to designate for those purposes. So, and then, of course, a huge focus for us over the last few years has been pay equity issues. And so over the last few years, you probably saw California had passed laws prohibiting consideration of prior salary history and requiring that we provide salary ranges to applicants upon request. Well, we decided to go further this year. And so we're now requiring that employers post the pay salary information in the job posting itself.
Mm-hmm. Similar to California or Colorado's laws. Is that the kind
I
of?
think that one's heavily modeled on
Yeah.
Colorado and perhaps New York City's as well.
So, like, let's just go through those that you mentioned, like bereavement leave. Um, when California says you've got to give somebody bereavement leave, can you just say, okay, we're giving X hours of PTO and you can use some of it for bereavement leave? Or is it, you have to have time set aside specifically in a category just for bereavement leave?
You have to allow them to use it for the purposes that would qualify for the leave. So upon the death of a family member, they have to be able to use that time for bereavement leave purposes. That just gives them the time off because it's unpaid, but they are allowed to draw upon PTO and other things you may have set up to help pay for it.
And how much time is that?
Up to 5 days.
Up to 5 days. So an employer has to grant up to 5 days, or is there a scale based on tenure, or is it?
No, it's 5 days. I'm sorry. Yeah, they have to provide 5 days.
Interesting.
Yes.
Wow. And okay, I've got a family member who's used my own death twice to get out of work, so she would have had 10 days. Okay, well that's interesting. What about marijuana usage? And we're seeing there's a lot of those, increasing laws around the country, especially at the municipal or the county level. But what's California's take on marijuana right now as far as usage? Because 2017 it became recreational use became legal. I was in California. I was in Oakland in January, the second week of January of 2017. And there was just like a cloud over the whole city. It was pretty skunky. So, but what's the rule now for employer consideration of marijuana?
Yeah. So right now, California statewide, we allow recreational medicinal purposes. With regard to the employment side, the issue was, well, under what circumstances can they discipline employees? And one of the concerns they had was that employers were still disciplining employees for conduct that was otherwise legal. And so we've now amended our Fair Employment and Housing Act to prohibit discrimination against employees for off-duty or away from the worksite usage. So you can't discipline people for using what is otherwise a legal product. And secondly, we're changing our testing laws. The concern being that the testing was only picking up if an employee had used marijuana at some point, but wasn't picking up active impairment. And so they've directed employers to begin using new tests to actually test for active psychoactive antigens that would show actual impairment, as opposed to, hey, they might have used it 3 weeks ago.
Can they do random testing, or does it have to be reasonable suspicion, post-accident type testing?
I believe it's going to depend on the industry. But as a general proposition, you're probably going to want to be doing it upon reasonable need, as opposed to just randomly. But again, it's going to be somewhat industry specific.
And really, it's only current impairment, which is interesting because we do drug testing too, and the impairment technology is not that reliable either. So I mean, there's a lot of disagreement in the industry about how accurate that impairment testing is. But. It's above my pay grade. I just trust what the scientists say.
Well, that sounds like a good venture if you or I could figure out a way to come up with the new test that everybody uses.
Yeah. And so paid sick leave, what does paid sick leave look like now in California, or will with the next, whenever it's implemented?
So right now what we have is we have 3 days off, and basically upon need for yourself or for a family member. And the change that was made this last year was to also allow you to be able to use it for a designated person. So it doesn't have to be taking it off because your son, husband is sick. You can now use it for whomever you designate as that person. And the employer can limit you to one designation per year, but it doesn't have to be a family member. So that was a change this year. The change I expect in the upcoming session will be to increase the levels from 3 days to 5 days in terms of the statewide bill, in terms of the amount that you could take off. And of course,
so that designated. I'm sorry. Go ahead.
I was going to say, and then of course in California, because we don't have preemption laws, once we go ahead and pass it to 5 days on the statewide level, then of course San Diego, LA, San Francisco are probably going to have to bump theirs up as well above that.
And let's take a quick break. Good Morning HR is brought to you by Imperative, premium background checks with fast and friendly service. On March 8th, I'll be hosting a webinar entitled Ethical Considerations in Talent Acquisition. We'll discuss the relationship between individual and organizational ethics and engage in an interactive conversation around a number of common ethical challenges that we face in recruiting, interviewing, and selecting employees. This free webinar is approved for 1 professional development credit for SHRM certified professionals and 1 hour of general recertification credit for HRCI certified professionals. And you can register for this free webinar at imperativeinfo.com. And if you're listening to this podcast after March 8th, you can still watch the recorded webinar on our website for credit for free. If you're an HRCI or SHRM certified professional, this episode of Good Morning HR has been pre-approved for 1/2 an hour of recertification credit. To obtain the recert information, visit goodmorninghr.com and click on Recert Credits. Then select episode 84 and enter the keyword Left Coast. That's all one word, LEFTCOAST. And now back to my conversation with Michael Kalt. You mentioned preemption. We're in session right now, and we don't have preemption in Texas because nobody ever dreamed that our cities would get so nutty. But of course, so many Californians have moved to Austin that we're now having to deal with some of those things, and preemption died, I think, in the calendars at the very end of the session last year or year before last, and it's on the docket again this year, and hopefully we're all hoping certainly we get some preemption because, like California, Texas is a really big state, 254 different counties, and Lord knows how many cities, and it's hard to do business in a place in multiple jurisdictions and keep track of all these little paid sick leaves. And we do have preemption on wage control, wage related issues. So PSL got struck down when a couple cities put in paid sick leave. But that designated person, do you have to designate if Joe gets sick this year, I get my days, or is it just wait when somebody is sick, you designate, okay, I'm going to use my time for this person, then you designate them?
I would say it somewhat depends upon how the employer sets up the policy, because the employer can limit the employee to 1 designation per year. So you could say, hey, you're going to have 1 designation per year, and they can make that in advance, or I suppose they could use it at the time they want to use it, and then they're limited to who that person would be. But if you don't have a limit on it, then theoretically they could use it for whomever they want, as many times as they want.
But you only get 1 designation. But the idea is that, I guess, that people who aren't married, don't have kids, don't have immediate family, but are caregivers or have, significant others who they're not legally connected to, maybe want to, but they want to give care if somebody needs that assistance. That's the idea, I guess, behind that.
That's exactly the concern, being that the nuclear family, that was sort of the definition for FMLA and our PSL purposes, didn't work as well in the modern environment where, I don't know if you've seen this TV show Modern Family, where you may have a whole host of different relationships. Yes. Exactly.
And so what are they doing on the pay equity front? Because I know y'all have long had, for a number of years, the salary inquiries, prohibition. What else is going on there on pay equity?
Yeah, the 2 big changes this last year were to require that employers post the salary range within the job posting itself so people can go ahead and see it. I would say 3. That was 1. Then secondly, the requirement that any current employee who wants the salary range for their position can ask for it, and you have to provide that to them. And then third, we have this requirement that larger employers need to annually submit what they call a pay data report to the DFEH. They've now expanded that, so you not only have to include that information for your employees, but also labor contractors, if you have a certain number of labor contractors. The idea being that a lot of employers, kind of the way water sort of gravitates or moves around, that because they were tracking for employees, that employers were hiring contractors. And so now they want you to go ahead and include that information for contractors so they have a holistic view of what everyone's getting paid.
So that sounds like that's the real power down, I would guess, for most employers on those 3 issues. Even if you are reporting it, it becomes like your EEO1s or something else. It's just another administrative burden at the end of the year. Plus, you're perhaps putting Exhibit A in some plaintiff attorney's hands at some point, or some state regulator's hands, by how you respond to that.
You hit the nail on the head. So I would say two things about that. One, when the law was initially enacted a couple of years ago, employer concerns was this was going to be one more thing we have to do. And they said, well, you can just use an EEO1. And now they've gotten rid of that and said you can't just use an EEO1. You have to actually go ahead and submit a report. And then secondly, employers were worried, well, where's this information going to be able to go? And initially they were saying, hey, don't worry, we're not going to be making this public. And now they are going to be making it public. And then the concern is, well, who's going to be using this information for what purposes?
On the employee asking what a salary range is for my current position, and I want to know where I'm at in the range, I guess. But does that apply to every employer, or is there a certain number of employees that an employer would trigger that?
Well, for the job posting, in terms of posting the salary range in the advertisement for the position, that's only for employers with 15 or more employees. Now,
in the
that's
state.
What's that?
15 or more in the state, or is it?
I believe it's anywhere.
Okay.
I believe it's anywhere. Yeah, so it's pretty onerous. But with regard to providing the pay scale to a current employee upon request, that's employers of any size, not 15 or more. And of course, you're 15 or more, it's not much of a difference because it's pretty hard to be smaller than 15.
So that means, that does mean a small employer with 3, 5, 10, 15 employees that doesn't have an HR department or, and certainly doesn't have a comp plan other than I'm the owner and this is what I can afford to pay right now. How do they respond to a request like that? I'm assuming California is like, I should never say California is like all the other places, but the majority of your businesses are probably small to medium sized businesses. And a lot of them are small, family owned type businesses. And I guess I'm just trying, how does an employer like that comply if I don't have salary bands? I'm paying you $15 an hour right now, or whatever I don't even know what minimum wage is in California. Is it $14 or 15 or?
It depends on where you're at. $15.50 is the statewide version as of 2 weeks ago. But of course, a lot of municipalities are significantly higher.
Okay. So I'm saying, let's say it's 18. This is what I can afford to pay you. Is that, but if you're threatening to leave, I may kick it up $2 more. Is that what, I don't understand. I'm not sure how a small employer would reply to that inquiry fairly and not get in trouble on the regulation side.
I think you're probably going to be safe in that circumstance to say, hey, this is what I've reasonably determined is the pay range for that position. I think you're going to be fine for that. Yeah.
And the employee will always be at the top of the range, whatever you quote them. So yeah, that's interesting. Okay. So as employers start to get ready for all of these things to roll out, what are the major things that employers who have locations in California need to be thinking about? And if all this goes into effect next January, a lot of it goes into effect next January, what do they need to do in the next 11 months to really make sure they're ready for it?
Are you talking about what's on the agenda for 2023 or what happened in 2022 that just took effect?
Oh, I guess it just took effect. Okay. So what happened in 2022 that just took effect, and what do they need to be doing right now to make sure they're compliant then?
Yeah, I would say you need to be looking over your policies for a couple things. One, updating for bereavement leave purposes. Secondly, updating your CFRA and your paid sick leave to make sure you're allowing the time off for designated
Tell us what
persons.
CFRA is.
I'm sorry, that's our California Family Rights Act. It's our state law equivalent to the Family Medical Leave Act. Okay. I would be looking at your equal opportunity policies to make sure you're not discriminating against anyone for marijuana usage away from the workplace. And then we also had a rule, of course, a lot of states responded to the Supreme Court decision in Dobbs on abortion rights. California did the same. So we had a bill there that protects employees on the basis of reproductive decision making. And so you cannot discriminate against an employee because of any decisions made related to contraception usage or reproductive services, which would include having had an abortion. So you would need to look at your policies there to make sure you're not discriminating on those bases. And then I would look at your job posting requirements to make sure where you need to have the job salary range posted and that your frontline supervisors know to turn over that pay range information if requested by a current employee. Those are just a couple of the things.
Yeah. And on that pay range posting, I've seen in Colorado, New York City, where employers are saying the range is between $15 and $200,000. Is there, do you have any read on how that would fly in California?
I'm going to guess that will not pass. We did recently have some frequently asked questions posted on the DLSE on this, and I would say you have to have a reasonable basis for the range that you came up with. So if you said, "Hey, it's between $65,000 and $75,000, depending on your experience, things of that nature," you're probably going to be fine. Something between one and infinity is probably not going to get it done.
And so we're in 2023 now, which seems really weird to say, but what's on the next 2-year agenda then? What do you think the big things that legislators may do to employers in California?
I would say there's a couple things that are definitely coming down the pike. One, paid sick leave is almost certainly going to increase. I think it'll go from 3 to 5 days. What we're hoping to do via CalSHRM, and I'm sure the chamber wants to weigh in on this as well, is recognizing that's likely to happen, to say, hey, if we're going to do that, can we have some preemption help for us here? I mean, that's particularly important when you think about working remotely now. My San Diego employees may be working in Los Angeles now. So now I'm subject to 3 different laws: California, San Diego, and LA. And if God forbid they spend 1 day a week working in Glendale, then I'm subject to a 4th law. So we'd like to have preemption. Predictive scheduling, very likely to happen this year. LA just passed a fair work week ordinance. San Francisco has one. Fully expect California is going to try to do something on a statewide basis. The question being whether it'll be limited to particular sectors or if we'll go broader than that.
So by predictive scheduling, you're really talking like 48-hour notice before your schedule changes or something like that, some mix of notice before somebody gets called in.
Exactly. A certain deadline by which a schedule has to be posted, and then a limit on any changes that could be made. And then, of course, California being California, we're usually requiring that any changes that are made after that time period would involve increased compensation to the employees.
Okay, of course.
Yes. And then I think workplace monitoring is going to be a really big issue. And in 2 respects, there were 2 really big bills that were pending last year that didn't happen, but we expect they'll come back. One will deal with the employer's ability to monitor employees through use of electronic monitoring for their remote employees. So checking when they're working, where they're working. There'll be something along those lines. And then again, saying we don't like to be behind anyone else. We know what Illinois has been doing regarding biometric information. We're trying to pass a law that's very similar to it. We're just hoping we won't have the same experience that they've had in Illinois with it. But I think that will definitely be back as well. That one seems less likely to be enacted. But of course, the votes are always there, and it will be a big push.
I just had another thought. I'm back on the paid sick leave. And so that's got to be, right now you said it's 3 days. And you think it'll be increased beyond that to maybe 5 or something?
That's my guess. 3 to 5.
And so in that can't be commingled with a regular paid time off pool that you may give your employees, right?
It can be, actually.
Oh, it can be. Okay. So how does that work?
Well, it can be. You just have to provide a certain amount of time that can be used off. And if the paid time off can be used for the same purposes as the paid sick leave law, then it can count.
So if I've got an employee and let's say, we do, 15 days of paid sick leave or of PTO on an annual basis. And in February, that employee burns through all their PTO, but then they get sick in May, and their PTO before all 15 days was just used for, a vacation in the French Alps. But then now they're sick in May. Does that PTO that they used for fun still count against what they had set aside, what they could use for PSL, or does it have to be? Did they have to use 5? At least tell me 5 of those days of PTO were used for illness. Does that make sense?
I'm going to be honest with you and tell you I don't know the answer to that off the top of my head.
Interesting. So, but if they use all their PTO for whatever reason, there's still, does the PSL does the employer point just back to it and say, hey, you used your PTO already, or? or is it just or is it just a thing we'll have to figure out as we go along?
No, there are very specific rules on that. I just can't remember them off the top of my head. I wouldn't want to quote the wrong thing to people, but I know that there are abilities in advance to have alternative plans rather than specifically designated PSL, but there are very specific rules about setting them up.
So they at least gave you some flexibility as an employer. If an employer is particularly more generous than what state law is, there may be a way to structure your paid time off plan around that.
Correct.
So we're running up on the end of time, but in 2022, 343,000 more people moved out of California than moved into California. It's the highest loss of any state in the country. Does anyone in California leadership seem to recognize that as a problem? Is there any conversation, or I'm sure the business community is saying something about it, but is there any conversation at the leadership level in California that, hey, this is a problem and we need to figure this out?
To be honest with you, sadly, no.
That's crazy. Well,
and I would say in part, they sort of deny that it's really even an issue. Our lieutenant governor recently posted a story about how, notwithstanding the 500,000 had left, that California ranked pretty high in happiness scores and some other categories, and said, "See, it's not really a problem if people leave." So I don't think that they're really that concerned.
Well, I guess if all the unhappy people leave, I guess that's the case. Yeah.
Well, and that may be what they're thinking now. The rubber has to hit the road at some point. And, we went from bragging a year ago that we had a $75 billion surplus to now we're talking about a $25 billion deficit. That may capture, one's attention. And then secondly, California is not immune from the labor shortage that other people are suffering from. And we do have this really interesting dynamic, because I think you mentioned manufacturing in Texas. We have so many white collar headquarters up in Silicon Valley, but it seems like all of our manufacturing is being shipped out to other states. And so you have this huge gap between the really rich and the really poor, but most of our middle class seems to be moving for a whole host of reasons, including affordability reasons. So I think it will capture the attention at some point, but I don't think that's a focus just yet.
Well, that's all the time we have today, but thank you for joining me, Michael.
It was a pleasure.
And thank you for listening. You can comment on this episode or search our previous episodes at goodmorninghr.com or on Facebook, Instagram, or YouTube. And don't forget to follow us wherever you get your podcast. Rob Upchurch is our technical producer, and you can find him at robmakespods.com. And thank you to Imperative's marketing coordinator, Marianne Hernandez, who keeps the trains running on time. And I'm Mike Coffey. As always, don't hesitate to reach out if I can be of service to you personally or professionally. I'll see you next week, and until then, be well, do good, and keep your chin up.